Sir.
Jonathan DeHaze.
All right. Go ahead. Now. What are we doing?
Yeah, there was a matter of a bond violation that was issued. Apparently, my client presented himself on November the 27th. We appeared before the magistrate. He was arraigned on the warrant. There were certain bond conditions that were set, one of which was to check in with community corrections and register. He was also to enroll in a drug testing program. Apparently, there was some confusion about the community corrections contact portion, but he did enroll in a drug testing program. He was allowed to test in Macomb County where he lives, and but apparently did not.
Who allowed him to test in Macomb?
I'm sorry. I didn't hear you, Judge. I'm sorry.
Who allowed him to test in Macomb?
That was the magistrate indicated that at the time of the arraignment. She said he made a test in Macomb
He
County.
testing.
He enrolled at a place called Adapt in the city of Warren, and he did.
Do we have any results?
He submitted the one test there. I don't have any results, but I did have verification from the place that he did in fact sign up for testing there. Once it was brought to our attention that he had failed to contact community corrections, he did then call community corrections to try to enroll. They told him because the matter was in warrant status, they couldn't address it. We'd have to deal with the court. He turned himself in for immediately or shortly after finding out about this. He presented himself last week to the jail and was told that he'd have to address the issue today because today was his court date for probable cause conference. So I don't think there was any part on Mr. DeHaye's part to not comply. It was just a matter of some confusion on his part about contacting and meeting with community corrections directly. I think he is 32 years of age. He is working, steadily working. He does have a young child he supports. As I say, he did voluntarily appear both.
Does somebody have the test result? Where he's testing? He didn't do anything. He didn't go for intake, nothing.
I went to.
He didn't
Am I
go
allowed
to
to speak, Your Honor?
corrections, but he did enroll in a testing program, and he did attempt to make an appointment to go to community corrections, but the matter was already in warrant status. So he did appear, as I said, voluntarily, both in November and in December, on learning of this warrant. So he's not. I don't think he's trying to deliberately avoid any responsibility, Your Honor. And if given the opportunity, I do think he would comply. He does have counsel. He is anxious to address this matter. He asked the court to consider reinstating his bond. Thank you.
Landy, before you explode.
Thank
Yes.
you so much, Your Honor. Your Honor, the people are going to request that the court review the bond decision made by the magistrate in this case and find an abuse of discretion. The facts alleged in this case are, first of all, that this is already by third offense.
Can I just say, you're
Yes.
saying on the original one? Go ahead.
Yes, the original one, but I understand the bond has been denied right now, but the conditions ordered by the magistrate, the people feel were an abuse of discretion and were not sufficient to ensure public safety. This is an alleged OWI third offense with an alcohol BAC of 0.120, cocaine and THC were also present in the defendant's system. I think if I didn't already say there was a crash, and his priors are from 2017 and 2021. People would request that he have at least intermediate, if not strict supervision from community corrections, as well as an alcohol test in place prior to any release.
Anything else, counsel?
Well,
I mean, is he in a treatment program? Or is he just testing?
it was just testing. That was all he was ordered to do at the time of the arraignment on November the 27th. And he's working. He supports a young child. He's, as I say, he turned himself in not only on the original warrant, but he turned himself in voluntarily as soon as he found out that there was a violation. He immediately turned himself in, and the communication that I received from the court was either he has to turn himself in or they'll address it at the time of the probable cause conference, which was today. He turned himself in as soon as he could, which was turned out to be last week, and he's been in jail for the last 6 days. So I don't think there's any attempt on his part to to try to avoid his responsibilities here.
Right, but counsel, I'm not clear how we got a PR out of the gate if the allegations are even near true.
Well, he is charged with a OUIL 3. That is true. That was known to the magistrate at the time. We presented information about his background, as I've done here today. And the magistrate's the one that set the bond conditions. So I'm not sure. There was nothing unusual about the case, that there was no injury involved in the case. It is still just the 5-year max. So I don't think there was anything that the magistrate was not aware of under the circumstances, certainly from the face of the file or any additional information. As I say, we provided his background information, which I restated here today. So he is employed, and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared. He didn't wait till today's date. He came in early to present himself to try to address the situation early, and they said because there was no bond that was issued with the order, that he had to sit there, and has sat there for 6 days. So he has obviously suffered some penalty.
Where are the test results?
Your Honor, I don't have them with me. I
I'll
don't
tell you
have
what,
test results.
before I do anything, because you're just going around in circles. You're telling me all of this stuff, but it doesn't make any sense to me because I don't have any test results. You're telling me he contacted community corrections after he's in bench warrant status. I have someone that's obviously a user. I don't have any testing whatsoever. Never reporting to community corrections. In my opinion, that poses a danger to the public because I don't know what he's doing. He's not in any treatment. He's not in anything.
Well,
I'll give him a bond.
Doesn't the file reflect that he was allowed to test in Macomb County? Because she put that on the record, the magistrate did.
But I don't have the results.
I
Follow
understand.
me here.
I
He
understand.
still would have to go to community corrections. He could test then in Macomb County. He has to sign a release. Those results get sent to us. I don't have any of that.
Understood. I'm simply asking, would the court allow him to be discharged, be released on a bond? He can report to community corrections before he's released from
Tell you what I'll
jail.
do. Because I honestly, counsel, you're not hearing me. So maybe somebody can figure it out. I'll set his bond at this point. I'll give him a bond. I think he's entitled to a bond now that he's appeared, albeit however he's appearing. I'll set his bond at 50,000 cash surety. I'll consider looking at that if somebody can provide me test results and I can set adequate conditions in regard to his supervision. But other than that, I'm not doing anything else.
Your Honor,
Yes, Ms. Lundy.
Could the court consider at least a 10% provision on that bond? I mean,
What?
would the court consider at least a 10% provision or something? Maybe.
No. You're just not following this at all.
I'm following that he went from a personal bond to now a $50,000 cash surety bond, and I don't frankly understand. He's voluntarily turned himself in twice in this matter in less than a month's time. And I know the court doesn't have any.
That's the fourth time you told me that. I get it.
But it's a substantial bond modification. And
Ms. Lundy.
Thank you, Your Honor. If the defendant is released, will that be with a crime alcohol tether if he's able to post a $50,000 bond? I'm so sorry, I didn't hear the court.
Yes,
Thank you.
it would be with a scram tether and intermediate supervision through community corrections. So what I'll do, in fairness to your client, counsel, because I don't, if those results are out there, you can get a document from him to get the results so that I can have the results, and I may consider something else regarding his bond, or I may not. But I'll give you a week to get that. I'll just adjourn this out 1 week to the 26th, and we can see what we can come up with. If I don't have any testing, I'm not changing.
All right, can we schedule this matter for an exam?
Is all discovery complete?
Yes.
I didn't hear your answer.
Yes, it is. I believe it is.
People have their witnesses available in a second.
We'll try, Your Honor.
Preliminary examination in person, January 2nd, 2025 at 12 noon. That's before me.
Thank you. Better just one more item on this.
I'm sorry?
Sorry, I just had one more question regarding the DeHaze matter.
Sure.
Is the court? Did the
He's
court
not
say,
here anymore. He's been taken back, but go ahead.
okay, procedurally, did the court say it would entertain a request for a bond or review the bond again upon presentment of some information regarding the testing?
I need to see that he's testing. You're
Okay.
telling me he was testing.
Right.
I don't see it.
Thank you. I'll see what I can come up with. Thank you.